final hearing or argument today is in the case of Curtis Markins versus Southwest Airlines, case number 29019. Both parties are represented by counsel. Each party will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you plan on reserving any time for rebuttal, and I'll keep track of that for you. As you may be aware, the arguments are recorded and posted online, so please keep your voice up as you address the court. And we have read the briefs in this matter and are prepared to proceed if you are.
Thank you. Good afternoon, Your Honors. May I please report, my name is Christopher Lalick, and I represent appellant Curtis Markins. I would like to reserve 5 minutes for rebuttal. Thank you. The issue to be decided in this appeal is whether appellant's claim of disability discrimination under Revised Code 4112 is preempted by the RLA or the Railway Labor Act. The analysis, or the answer to that question is set forth pursuant to the analysis that was given by the United States Supreme Court in its 1994 Hawaiian Airlines versus Norris decision. Pursuant to the analysis set forth in that opinion, the answer as to preemption is no. There is no preemption here. This is a disability discrimination case under Revised Code 4112. While Mr. Markins did have a collective bargaining agreement, because he was a member of a union in connection with his employment, none of the terms of that collective bargaining agreement are in dispute here. And that is the dispositive point on the issue of preemption as set forth by the Supreme Court in Hawaiian Airlines. Specifically, the Supreme Court noted there that the preemption analysis turns on whether the meaning of the contract terms are in dispute.
Counsel, I was just going to ask you, so you're not disputing, or your client has not disputed ever that the employer here, Southwest Airlines, had the right under the contract to ask for an independent, neutral medical evaluation and to put your client on leave?
That is correct, Your Honor.
I thought that was part of, and I'm not sure this is part of the record yet, so we'll have to be talking about that as well. But with the arbitration, I thought that was something that was...
So maybe I should clarify my answer then, Your Honor. As a part of this case, that is not an issue. In this case, the issue is not whether or not there was a contractual right. For the purposes of this litigation, there is no dispute as to that. It is an accepted contractual right, Your Honor. However, it is the intent in exercising these rights that is an issue here. I might analogize this. I think, at least for me, it's a good way to conceptualize it. If you were to compare this, for example, in an ordinary employment at will case, in an employment at will relationship, there is no dispute that an employer has a dispute to terminate an employee. That is an absolute right of an employer. However, if the employer exercises that right, and as a result of discriminatory animus, well, Ohio law under Revised Code 4112 provides a right to the employee to bring suit. That is the very same right that's at issue here. There's no dispute that there's a contractual right here. The only thing that is in dispute is really an issue of fact as to whether or not Mr. Markins is correct in his allegation that he never did indeed have a seizure and there was no basis for it, and whether or not he's correct that Southwest Airlines and Mr. Crum exercised discriminatory animus in alleging that he did, leading to his suspension.
What is the adverse action that you're alleging happened that is based on his disability?
Well, Your Honor, he was placed on a unpaid leave of absence for an indefinite period of time. So that would be the adverse action.
Per the CBA?
Correct, Your Honor. Again, it's similar to a termination situation, Your Honor. There's no dispute that there was a right to put him on a unpaid leave of absence. The issue is whether or not, an issue that we would like to try before the trial court, is whether or not discriminatory animus was the reason that that contractual right was exercised. So as far as the underlying case here is concerned, there would be nothing, perhaps because, as Your Honor indicated, the employer did have a contractual right. Potentially, there would be a reference to the collective bargaining agreement at some point in there, but there's no dispute as to it. Mr. Markins makes no allegation in connection with this litigation that right was improperly applied, aside from the discriminatory animus, of course.
Thank you.
Essentially, the trial court, well, before I go there, the reasoning set forth in Hawaiian Airlines in every case at least every case that I'm aware of that had considered this issue since 1994, is the same, which is that just a reference, just a mere reference, such as the fact that there is a contractual right, does not warrant preemption. It takes there to actually be a dispute regarding that for preemption to apply. So the trial court here arrived, obviously, at the opposite conclusion. However, in doing so, the trial court relied on some law that predates Hawaiian Airlines, and in fact has been overruled by Hawaiian Airlines. The first case that was relied on by the trial court was Heddlestad versus Conrail Manufacturing Corporation. That's a 10th District of Ohio case. It was decided in 1991, though, 3 years before Hawaiian Airlines. And in that time, when that case was issued, there was a split of authority, and in fact, the Sixth Circuit applied a different standard to preemption analysis. Specifically, they used what was called the inextricably intertwined standard, which reduced it to those simple terms, means that if there were any common issue of fact that at all were to come up in an arbitration, then it would be the preemption would apply. I would submit to you that if we were having this conversation in 1993, this court should find the other way, pre-Hawaiian Airlines. However, Hawaiian Airlines changed that. Specifically, the trial court's opinion actually cites to some language that itself is very much at odds with Hawaiian Airlines and its progeny. For example, page 7 of the trial court's opinion states, plaintiff's ability to perform his essential job functions requires reference to the collective bargaining agreement to ascertain the relevant performance standards and working conditions. So simply, just because there was a reference, the court would, at some point in litigation, they would look to the collective bargaining agreement, that would be enough. Well, that's clearly not the standard under Hawaiian Airlines. As a matter of fact, that word reference is explicitly called out in Hawaiian Airlines at 261 footnote 8, when the meaning of the contract terms is not the subject of the dispute, the bare fact that a collective bargaining agreement will be consulted in the course of state law litigation plainly does not require the claim to be extinguished. Mere reference does not require the claim to be extinguished. In addition, the trial court relied on, in addition to the Heddlestad case, the trial court relied on another pre-Hawaiian Airlines case, Calvert versus Trans World Airlines. It was actually an 8th Circuit case from 1992. Now, in the 8th Circuit itself, obviously, persuasive authority potentially here, but I would submit that if the 8th Circuit itself no longer finds Calvert's analysis to be good law, neither should this court. And that's exactly what the 8th Circuit has held subsequent to Hawaiian Airlines. Later the same year, 1994, after Hawaiian Airlines was issued, the 8th Circuit came out with its opinion in Taggart versus Trans World Airlines, which explicitly stated that Hawaiian Airlines has narrowed the scope of RLA preemption and actually reversed the trial court that relied on a Calvert analysis. As far as its preemption analysis is concerned, Calvert's no longer good law, even within its own circuit. So I would submit that it would not be here. Your Honors, unless this court has further question, I would yield to my colleague.
Sharp?
No, thank you.
Good. Shelley? Well, you're at 5 minutes and 30 seconds, so you will have 5 minutes for rebuttal.
Thank you.
And counsel, you'll have 15 minutes.
Thank you. Good afternoon. May it please the court. My name is Natalie Stevens. I'm an attorney with Ogletree Beacons, and I represent the appellees in this case, Southwest Airlines Company and Jeffrey Crum. We thank the court for the time today to further explain why the trial court's decision dismissing Mr. Markins' disability discrimination claim under Ohio Revised Code 4112 should be affirmed, and to answer any additional questions that the court may have after reading the briefing. Knowing that you have read the briefing and do have the benefit of a very thorough statement of facts from both sides and representation and citation to the record, I will avoid a complete recitation of those facts for you unless, of course, you have questions about specific facts. I'd be happy to answer those. With that said, I'll go ahead and get started. The RLA was enacted in order to promote stability in labor management relations by providing a comprehensive framework for resolving labor disputes. The RLA preemptively controls labor disputes that require interpretation or application of collective bargaining agreement terms. There is no dispute here that Mr. Markins was subject to a collective bargaining agreement that controlled his employment. It is disingenuous for appellant to contend today that none of the terms are in dispute here and that he's not disputing the right to request a fitness for duty exam or to place Mr. Markins on medical leave, given his own allegations in the complaint. What does he say in the complaint in regard to that? That's a very good question, Your Honor, and I will address that specifically. He claims that Southwest wrongfully regards him as unable to perform his job due to his record of having a disability, and as such has placed him on unpaid and indefinite medical leave. He also claims that the statements that Mr. Crum made form that basis for the decision to place him on the unpaid medical leave and to refuse to reinstate him. So in essence, his entire claim derives from the request that he submit for an examination by a doctor of the company's choosing, which is specifically authorized and addressed in the collective bargaining agreement.
Is that what it says, or is it saying that the employer made the wrong decision based on what the doctor ruled, or the doctor was incorrect, and the employer made the wrong decision because the doctor was incorrect, which really wouldn't have anything to do with the collective bargaining agreement, would it?
I think that's also a good point, Your Honor, and I think it all stems from the basis in which an employer can request that examination and upon which it can rely upon the information contained within that examination. Without the collective bargaining agreement, the employer may not do that, may not go through those steps. And that right there provides the basis for the employer's decision-making process. And thus, in order to evaluate and decide appellant's claim, the disability discrimination claim, the court will need to interpret and apply those provisions of the collective bargaining agreement.
Okay, I understand what you're saying, but I'm just throwing this out as the appellant is saying, well, we're not contesting that. We'll stipulate that they had the right to do that. So all the issue becomes is, in your interpretation, employer, of the medical examinations, did you not reinstate him based on animus? Now, they might lose, but was it based on disability, wrongful disability discrimination, or was it based on the doctor's decisions?
And I think what the employer would say is that it took into account a number of different things in connection with that decision-making process, including the appellant's own doctor's opinion initially that he couldn't perform the essential functions of the job, including a statement from a coworker, including it's a right to request those examinations and to rely upon those examinations pursuant to the collective bargaining agreement. So all of that combined, but in order to get to the analysis in that point,
the court would need to, and the parties would need to, interpret and apply the terms of the collective bargaining agreement with respect to the examination and also with respect to medical leaves of absence. While appellant may stipulate that the company has the right to request that medical examination and to place the employee on leave, appellant is not stipulating to the employer's right to continue the employee's medical leave as a result of those examinations which were taken pursuant to the collective bargaining agreement. That piece of the puzzle also requires interpretation and application of the collective bargaining agreement, because the collective bargaining agreement says that once an employee is on a medical leave, the company has the right to require them to go to another examination by a doctor of the company's choosing and can rely upon that before returning the employee to work. So the ultimate issue in the case is not return to work, which is subject to those terms of the collective bargaining agreement.
I understand it, so they're saying though in reply, we don't care about all that. All we care about is what's your real motive. And isn't that just an issue of basically being, they may not be able to prove it, but isn't that just the working of what this case is about?
Well, I think you make a good point, Your Honor, and I think that it's just not consistent with the briefing that appellant provided in the trial court level or in this Court of Appeals.
What about the court's entry? Did the court's entry address the discriminatory, was it based strictly on interpretation of the CBA, or did they talk about the fact that in the entry, that plaintiff's doctor originally said he was unable to return to work and therefore there's no discriminatory intent here?
The court did not, that's also a very good question, Your Honor. The court did not specifically address the initial doctor's non-return to work and the placement on a restriction with respect to driving, but it did go into the analysis to say that there are a line of cases that say if a decision requires a purely factual inquiry to motive, then RLA preemption would not apply. If there's a line of cases that say if it's beyond purely the factual motive and it still requires interpretation and application of the collective bargaining agreement, then RLA preemption would apply. And it found that in this circumstance, based on the facts that were presented, which were many, including affidavits from both sides, that it was not a purely motive question, that it did require interpretation and application with respect to the collective bargaining agreement. And it did so in a couple of different fashions. Specifically, appellant must prove a prima facie case, which requires him to establish that he could safely and substantially perform the essential functions of his position, which he cannot do without interpretation and application of collective bargaining provisions as they set forth the essential functions of the position.
But wouldn't that be just what Hawaiian Airlines is referring to, just mere reference to the collective bargaining agreement instead of actually controlling the underlying litigation?
Your Honor, that may be the case if appellant weren't contesting specifically whether or not he had to drive and work at heights. But in this case, he has contended that those really truly weren't essential functions of his position, and other people could have taken on those responsibilities for him. That's not supported by the collective bargaining agreement, essential functions that are set forth. It was also not supported by the decision of the arbitrator who evaluated similar claims and issues in connection with this appellant as well. There was an additional point that the trial court made as well, finding that it was beyond purely motive, specifically with respect to whether or not an adverse action was taken with respect to the appellant as a result of his disability. And in particular here, the question is it an adverse action if the company does not believe that he can safely and substantially perform those essential functions? And as such, he would not be a qualified individual with a disability under the Act afforded to protection. Then beyond that, he was provided a reasonable accommodation, even if he could establish that he had a disability in the form of a leave of absence, which the law does support. And the trial court went one further step to say that the pretext analysis also requires interpretation and application of the collective bargaining agreement. And that is also a critical point that appellant made in his brief. He brought up pretext, saying, if we could establish a prima facie case, the burden shifts to appellee to establish a legitimate non-discriminatory reason. The burden then shifts back to appellant to say that there was pretext. Specifically, that the reason provided was not sufficient to warrant the action that was taken, was false, or there's a third category. And in any of those categories, that also requires bargaining agreement as well. The third category is that it did not actually motivate the adverse employment action. So when deciding those three factors, it would also require interpretation and application of the collective bargaining agreement, specifically with respect to what the company's rights are, with respect to that fitness for duty exam, and also with respect to placing an employee on medical leave and continuing the medical leave as a result of those fitness for duty exam results.
Under the arbitration provisions, could an employee obtain adequate relief or the required relief or allowed relief, I guess is a better way of saying it, under the ADA and the state discrimination statute?
Yes, I believe so, and in fact, in this case, appellant did pursue a statutory claim in the
And is
arbitration.
that in the record?
And it was attached to our brief,
Right, but it has to be in the trial court record.
and it wasn't possible to include as part of the trial court record because the arbitration decision had not yet been issued.
So could you raise that as an affirmative defense? That is proceeding arbitration and maybe failure to exhaust administrative remedies or something like that?
We did bring up to the trial court that he had filed a grievance, so the trial court was aware of the fact that a grievance had been filed, and that he was pursuing parallel claims.
And you didn't attach that as an exhibit of the grievance to your motion to dismiss?
The grievance had not yet been filed at the time of the motion to dismiss, but it was filed as a motion for leave to supplement the briefing in connection with the motion to dismiss to the trial court. So it was attached as an exhibit there.
That's what I'm getting at. So it wasn't, the grievance itself wasn't in front of the trial court then?
Yes, that is correct.
Thank you.
I'm trying to find the.
Oh, that's okay, we'll find it. I just wanted to make sure.
Sure, that would have been docket entry 22 in the trial court's record.
Thank you.
The position that appellant has taken in connection with this case and that being attached and not being compliant with the appellate rule is, it was attached for two reasons. One, so that this court would understand the full procedural history of this case and that appellant did in fact pursue an arbitration. And two, so that this court would also understand that while appellant now contends that his statutory claim is not subject to arbitration, he did in fact pursue a parallel statutory claim during that arbitration. And that the arbitrator did decide after a full hearing in which both sides were presented up with an opportunity to present witnesses and evidence, including testimony from appellant himself, testimony from the individual defendant himself.
Counsel, do you realize we can't consider that? It was not part of the trial court record.
We would request that the court consider it as supplemental authority in connection with this case, in light of the fact that appellant is aware of the decision and it's not new to him, and that it was attached to our briefing. Even if the court should decide not to consider it, I would say that it is not dispositive of the issue before the court, which is whether or not the discrimination claim requires interpretation or application of the collective bargaining agreement. I would say also that the decisions that appellant relies upon are decisions in which the courts found that it was based on purely factual inquiry into motive, but there are plenty of decisions in which disability discrimination claims have been found to be preempted by the Railway Labor Act, where it was not a purely factual inquiry into motive, which we present isn't the case here today, but rather a decision which requires interpretation or application of the collective bargaining agreement. In particular, the Hogan decision, the Parker versus Metropolitan Transport Authority decision, and the Hattelstad decision. The Hattelstad decision, while appellant contends that predated the Hawaiian Airlines decision, remains good case law, and the analysis is the same insofar as the court decided that the claim was requiring interpretation and application of the collective bargaining agreement and was not independent of the collective bargaining agreement.
Counsel, can I ask you a question? Because I know you were, I think in response to something Judge Carr asked you, you were quoting from the amended complaint. But as I look at it, I'm reading paragraph 16. Acting in concert with defendant Southwest, defendant Crum falsely alleged that plaintiff had seizures while on the job in 2016, which plaintiff denies. Defendant Crum and defendant Southwest knew these statements were false. The purpose of defendant Crum's knowingly false statements was to aid and abet defendant Southwest's discriminatory conduct. How does that
obligations contained therein implement the collective bargaining agreement.
I would say that not that particular paragraph, paragraph 16, but if the court proceeds to paragraphs 20 and 21, those paragraphs specifically reference the medical leave and also the refusal to reinstate. And those are the particular issues that have not been stipulated to by appellant in connection with this case that do require interpretation and application of the collective bargaining agreement.
23 seconds left.
With that, we request that the court affirm the trial court's decision and dismiss granting the motion to dismiss on grounds that the claim is preempted by the Railway Labor Act. Thank you.
Thank you, Attorney Stevens. Attorney Levin, keep that 5 minutes.
Thank you, Your Honor. Thank you, Your Honors. So, in response to my colleague's response to me, reply, I would first respond to the request that was put before the court that the extra record evidence be considered. I would state that appellant became aware of that following its issuance, which was actually not before the trial court's decision, which is, of course, ultimately what's being reviewed here, but even after the first appellant's brief was filed, I would submit that if that needs to be part of the record, it needs to be remanded and re-litigated before the trial court. I would also note that frequently my colleague referred to, instead of using the word reference, she used the word interpretation and application of the collective bargaining agreement. But I note that so far what has been not at all referenced at any point in the briefing or any part of the conversation is what specific terms are in dispute here. Again, the Hawaiian Airlines case states that the subject of the terms, the meaning of the contractual language, has to be the subject of the dispute. That is not the case here. So to point at, well, they didn't return from absence, they exercised a right under the contractual bargaining agreement by putting them on an unpaid leave of absence. Well, that is absolutely one of their rights under the collective bargaining agreement, and we are not disputing that. The dispute is solely where all this started, which, as was pointed out by Your Honors, it was the fundamental question here is what started all this by Mr. Crum, which is allegedly according to the complaint, a false allegation based on discriminatory animus, and that's what's at issue here. Now, the other machinations, the other application of the collective bargaining agreement are all part and parcel of the collective bargaining agreement, but they're not in dispute. It's what was the impetus to those mechanisms being set forth. And again, I would note that the Heddlestead decisions, the language itself that was cited by the trial court is squarely at odds with Hawaiian Airlines. There's no way to reconcile those two cases. So I don't think that there's any argument that can be made that the cases are square with one another. Hawaiian Airlines indisputably narrowed the standard, and it is not in accordance with Heddlestead. If there are no other questions from Your Honors, I will yield.
Looks like there are none, so thank you very much. Thank you both of you for your presentations today. The court is going to take the matter under advisement, and we will issue a decision in due course. Clerk of Courts will mail each of you a copy of the decision on the day it is released, and the opinions are also posted on the Supreme Court of Ohio's website. So the court wants to thank you again for very nice presentations, and we will be adjourned until Tuesday, October 3rd.